Okay, our third type of dispute resolution is arbitration. Arbitration is more formal, more binding, and a little bit more intense than negotiation or mediation. We're going to start with the type of participation. Now, generally speaking, arbitration is voluntary, but it can be contractual or it can be court ordered. Sometimes, a lot of times actually, when two parties are engaged in a dispute and the goal is to, I guess, avoid incurring enormous court costs, things will be recommended to arbitration. Arbitration decisions are binding, unlike the other two, which are non-binding, and there is usually no appeal when you engage in arbitration. Arbitration, when you're talking divorce, this is a good choice for things like deciding on child custody, child support, spousal support, so forth and so on. If you use a mediator in your divorce dispute, you're going to find that the child support that your other half has agreed to pay you is not binding and they can simply not pay it, and you're really up a creek without a paddle at that case. So take my advice: if you guys are going to get divorced, go through arbitration, not mediation. Third-party participation, in this case, it is also party selected, just like with mediation. But in this case, you've got a decision maker, Now, this is different from mediation because a mediator is just a facilitator. The facilitator is there to help you come to an agreement between you and the person you're engaged in the dispute with. In arbitration, the third party is a decision maker. Okay, going back to the divorce example, if you use a mediator in deciding who has custody of the kids when, it's really up to you and your soon-to-be ex to come up with a plan for child custody. The mediator is just there to help you make the decision. However, the arbitrator will make the decision for you. If you're engaged in a non-contentious divorce and you really don't have anything that you need a binding decision on, you're okay with mediation. However, if you're having a contentious divorce, or if you need results that are absolutely binding and that you have the power to enforce, that's an important distinguishment. That's an important distinction. Then you need arbitration. Okay, what about the formality of the proceedings? Well, arbitration is more formal than mediation, but it is less formal than adjudication. Okay, now adjudication is when your divorce goes to court, and we'll talk about that in just a minute. Okay, also another distinguishing feature that makes arbitration different from mediation is that with arbitration, each party presents evidence or proofs to the arbitrator. Okay, now going back to our dog custody example, the arbitrator is going to be interested in the proof you have that you're the only one who ever took the dog for a walk. The mediator is not, but the arbitrator is. If you're going through, again, this just shores up the idea that if you're going through a contentious dispute resolution process, you are going to want to bring in an arbitrator. Now, there's a medium ground between mediation and arbitration called med-arb. That's a good option if you want to try and avoid some of the bad feelings that can arise in your relationship with the other party through the use of arbitration. Okay. The type of decision in this case is not mutually acceptable, but an arbitrator will try to reach a compromise between the parties. What's the difference between a compromise and mutually acceptable agreement? Compromise typically means that somebody is going to have to give up something and they're probably not going to be happy about it. All right, what about the justification of the decision? Okay, well, when it comes to arbitration, you don't really need to have a reason for the result. The arbitrator does not have to justify why he decided to give the dog to your ex, or why he decided that the kids should only stay with you during the week. Okay. The emphasis here is much more formal, whereas with the first two, negotiation and mediation, the emphasis was on keeping a congenial relationship between the two disputants. When it comes to arbitration, consistency and predictability become predictability become as important as the relationship. Okay, what does this mean? What does it mean when we say consistency and predictability are as important as the relationship? Well, what this means real simply is that the arbitrator is as concerned with following established rules of procedure, with following precedent, than either negotiation or mediation is. Okay? Arbitration is not as private as our first two types of dispute resolution. It is ideally private, but judicial enforcement can be sought. Okay? Now, what does this mean? How can we describe this? Well, the best way to describe this is to say that in the case of arbitration, there may be times when the compromise is not as acceptable to one party as the other. And when this happens, the arbitrator can request judicial enforcement. This could mean something like a protection from abuse order, or, oh crap, I can't remember what, my brain is my brain is failing me here. The type of order that you can get, a restraining order, that's it, or a restraining order. Okay, so again, just to reiterate, the arbitration process is private. That means that you keep the criminal justice system out of it, but in some cases when the compromise might piss off the other party, the arbitrator may request judicial enforcement, and at that point it becomes more public and less private. All right, and that is it for arbitration.